Good evening, everyone. I am Christine Lunato, and today I will be discuss the obligations of the partners. Partner as an agent of partnership. It is the nature of a contract of the partnership that is fiduciary. So from the word fiduciary, it is a trust and confidence governed by the partner, involving trust especially with regard to the relationship between trustee and beneficiary. Acts apparently for carrying on in the usual way of the business of the partnership. Kaya tinawag na partner as an agent of the partnership dahil sa isang partner, may nagaganap na partner is agent of the partnership. So dito may business tayong partnership, may business tayo. Then yung name ng partnership natin is ABC partnership. May business kaming telahan and yung tela ikakat and gagawing damit at tatahiin, which is ongoing production siya. That is the acts apparently for carrying on in the usual way of the business of partnership. But hindi kasama sa partnership namin ang gumawa mismo ng tela o mag-produce at mag-provide ng tela. So, the partner so acting has in fact no authority to act for the partnership. So, etong si partnership C ay nagbenta ng tela na ginawang damit kay X. So, sa ganitong scenario or case, it is valid and binding to our partnership because partnership C authorized to our partners. Pumayag kami, which is it is binding and valid to our partnership and obligation to deliver kay X, and this is a good way of transaction. The person with whom he is dealing has knowledge of the fact that he has no such authority. So dito na nga, but what if C is not authorized to sell to X? Hindi siya authorized to our partnership na kumbaga si C ay hindi siya authorized na mag-sell. Kunwari, ang gagawin niya lang is, kami ni A and B ay taga-sell ng mga ginagawa namin o pinoproduce naming damit. While si partnership C is, siya lang yung taga-audit ng sales or taga-inventory. So, here is, but what if C is not authorized to sell to X? And etong si X ay hinahanapan ng tela si partnership C at akala niya gumagawa kami mismo ng tela or nagpro-produce kami ng tela. So, dito sa part na to, hindi na part sa business partnership namin ang naganap na transaction ni C and X because they are in bad faith. Another example here is A, B, C, and D are partners in ABCD partnership, engaged in the selling of tables, chairs, and other furnitures. Subsequently, D sold 5 tables to X. So in this case, the sale is valid and binding to the partnership. ABCD, which has now an obligation to deliver the said 5 tables to X. So the question here is, what if D is not authorized to sell and such fact that is not known to X? So here is the sale is still binding to ABC partnership because the act of D in the selling table is an act which is apparently for carrying on in the usual way of the business of the partnership. It is not necessary for the X to ascertain if D has been authorized by A, B, and C to sell him his table. So in the next question, what if D is not authorized to sell and such fact is known to X? So the sale is no longer binding to ABCD partnership as both D and X are in bad faith. That is partner D knows that he has no authority and the third person X knows that D has no authority. So same lang siya ng example ko kanina about sa telahan, yung nangyari kay C and X na transactions. So, 2. Acts not apparently for carrying on in the usual way of the business of the partnership. It does not bind the partnership unless authorized by the partners. So, kung kanina, acts apparently, here naman is acts not apparently. So, here may example ako dito, which is sa isang mansyon may malaking bahay at pinatawag si partnership A, B, and C para linisin yung bahay, as in maglinis lang, yung tatanggalin yung mga alikabok, yung ganyan, may mga ayusin, lilinisin, ganun. Pero what if sinabi sa kanila nung may-ari ng bahay na ayusin yung mga sirang furnitures like table, chairs, and etc. So dito pumapasok ang acts not apparently for carrying on in the usual way of business partnership. Kasi naman, hindi siya part ng business nila na mag-ayos ng mga sirang gamit, ganon-ganon. Kasi yung gagawin lang nila is maglinis lang talaga ng bahay. So, here, it does not bind the partnership anymore. Unless it is authorized by the partners na, sige, gawin natin yung pinapagawa, ayusin natin ng mga nasirang furnitures, but it is another income or job by the partnership. So dito, umiikot ang unanimous decision of the partners kung saan gusto nilang madagdagan yung business ng partnership nila ay gagawin nila. So kaya siya tinawag na acts not apparently for carrying on the usual way of the business of the partnership, kasi hindi naman talaga siya yung part ng business nila. Example, yung gagawin lang nila, yung business nila ng partnership nila is tagalinis. Pero, what if dun sa acts not apparently is tinanggap nila yung gagawin, pinapagawa sa kanila na may aayusin silang mga sirang furnitures, which is hindi kasama na yun sa usual way of business nila. Kaya siya tinatawag na acts not apparently for the usual way of business. Pero dito pa rin umiikos yung unanimous decision ng partnership, ng partners, kung gusto nilang mas madagdagan yung income or job ng business nila. Here, may another example ako. A, B, C, and D are partners in ABCD partnership, engaged in the selling of tables, chairs, and other furniture. Subsequently, without authority from the other partners, D sold some of the woods and lumbers of the partnership to X. So in this case, the sale is not valid and binding to the ABCD partnership. And the question here is, what if D was authorized to sell by the other partners? Then, the sale is still binding to ABCD pa rin. Kasi here is, umiikot dito is unanimous decision between the partners to the partnership. Acts of ownership o ownership, the legal relation between a person, individual, group, corporation, or governed and an object. So, balik tayo doon kanina sa example ko sa bahay na may mansion. So, doon sa bahay na yon, yung may-ari ay binigay niya yung mga antik niyang kagamitan kay letter C, kay partnership C. That is acts of ownership. So, tinanggap ni C, syempre, at walang authority sa partnership nila. At etong si C, binenta niya ang mga antik na kagamitan kay X. So dito, hindi ito valid at hindi ito bind sa partnership ABC kung anong transaction ang naganap kay C and X. Pero kung authorized or pumayag ang partners nila C na sige, ibenta mo yan kay X at paghati-hatian nila ang nabentang gamit na mga antik na galing dun sa mansyon, then the sale is binding to ABCD partnership. Laging tandaan na authority here must come from all unanimous of the other partners. Kailangan yung decision nila ay tugma sa lahat ng bagay na gagawin nila. Then number 4 is acts in the contravention of restriction on authority. The act is not binding to the partnership as to persons having knowledge of the restriction. So dito naman ay example ko dito is si Head and Shoulder Shampoo Company. Nag-deliver ng mga stocks or Head and Shoulder shampoo. So ikaw sumisingit ka habang binababa yung mga stocks ikaw agad bumibili ka na agad doon sa mga nagbababa na may stocks, yung mga nagde-deliver, yung mga delivery man, which is act in a contravention of a restriction. So dapat yung gagawin mo dito, or dapat na tamang gagawin mo na ginawa mo is kausapin mo yung dapat na pagbilhan mo, like yung sales manager, or manager in charge doon sa transaction. Hindi yung doon yung kakausapin mo o yung pagbibilhan mo is yung delivery boy na nagbababa lang ng stocks. Equitable interest. So, an interest held by the virtue of an equitable title or claim on equitable grounds, such as held by trust beneficiary. So, first is the partnership. So, the conveyance here was executed in the partnership name or in the partner's name. So here I have example, A, B, and C formed ABC partnership. Later, C sold a specific parcel of land in the name of ABC partnership to X. In here, the sale is valid and binding to the partnership. So what if C has no authority to convey said the land? So the ABC partnership can recover the land. ABC partnership cannot recover the land if the selling of the land by C is in line with the operation of their business, which is in real estate business. Also, ABC partnership cannot recover the land if X is in good faith, meaning he has no knowledge on the lack of authority of C. Then next, one or more or all the partners or in the third person in trust for the partnership. So here, the conveyance was executed by the partner in the partnership name or in his own name. So example of here is ABC formed a partnership named ABC to engage in real estate business. So later on, C was authorized by the other partners to sell a specific parcel of land registered in the name of C in trust for ABC partnership to X, using either ABC partnership as the seller of C's name as the seller. In both cases, regardless of whose name the seller is, what passes only to X in equitable interest for the partnership. Again, the remedy of X is to ask for the reformation of their contract of sale, so as to clearly state the intent of contracting parties. Equitable interest will not be transferred to X if ABC partnership is not engaged in real estate business, or if C has no authority and X has knowledge of C's lack of authority, although the sale was made in the usual course of the business. Then, last is all the partners. So here, the conveyance was executed by all the partners passes all their rights in the such property. So another example is A, B, and C form ABC partnership again to engage in the real estate of business. So later, A, B, and C sold a specific parcel of land registered in their names. So, not in the name of the ABC partnership, but registered in their own names. So, to X, in here, the sale is valid and binding to the partnership. Admission. A statement in which someone admits that something is true or that he or she has done something wrong. So, admission by any partner is evidence against the partnership if first, the admission must concern partnership affairs. Second, the admission must be scope of his authority. So, take note that an admission by a former partner made after he has retired from the partnership is not evidence against the partner. So, the general rule here is that the notice to a partner is notice to the partnership. So example here is A, B, and C are partners in the A partnership. So later, X sent a demand letter to A, B, C partnership which was received by the partner B. So in this case, when B received the demand letter by the operation of law, A, B, C partnership also will be receive the demand letter. So here was kung ano yung matatanggap na letter ni letter C ay matatanggap din ni letter A and B. So, lahat meron silang matatanggap. Here was concerned or may awareness about their partnership. Instances where knowledge of a partner is considered knowledge of the partnership. So first, knowledge of the partner acting in the particular matter acquired while a partner. Second, knowledge of the partner acting in the particular matter then present to his mind. Then third, knowledge of any other partner who reasonably should have communicated it to acting a partner. So a careful reading of their provision shows that the notice to any partner under certain circumstances operates as notice to other to or knowledge to the partnership only. Evidently, it does not provide for the reverse situation or that notice to the partnership is notice to the partners. So unless there is an unequivocal law which states that a partner is automatically charged in the complaint against the partnership, the constitutional right to due process take uh, precedence, and partner must first be impleaded before he can be considered as a judgment debtor. So to the rule otherwise would be a dangerous precedent, harping in a favor for the deprivation of the property without ample notice and hearing, which the court can be certainly cannot countenance. So here is in the exception in this case of fraud or a partnership committed by or with the consent of the partner. So here, according to the Article 1821 of the Civil Code, does not state that there is no need to implead a partner in order to be bound by a partnership liability. It is provide that. So that's all, and thank you.